I'm Rebecca. I'm a foster care coordinator here at Skookum Kids. In this video, we're going to talk about what the legal case looks like from when a child enters foster care until they exit foster care. A child enters foster care when a situation happens at home or a community member is concerned and they notify intake. Intake then is called upon to investigate the situation and make an assessment. When they go out to the family's home, if they're concerned about the welfare of a child, they may call the police to involve the police in removing the child from their home, or they might go to the courts and ask for a court order to remove the children from their parents' care. Once children are removed from their parents' care, they enter into protective custody. Children are generally in this kind of situation of protective custody for 72 hours. During this 72-hour window, children might be placed in a foster home, they might be placed in a short-term shelter like our Skookum house, or they could be placed with a relative if a relative or family friend was available to the child. After that 72-hour mark, a shelter care hearing occurs. This shelter care hearing will happen no more than 72 hours after a child was removed from their parents' care. At this hearing, the CPS social worker is going to report to the court what their concerns are and why a child must remain in foster care or out of their parents' home. The parents will also be at that hearing and might have attorneys assigned to them at that point in time. If not, after that hearing, parents will obtain attorneys, and the attorneys will likely advocate for the children to return home to the parents. The court will make a determination as to if the children should stay where they are or if the children should return home to the parents. When the judge says yes, the child should remain in foster care at that shelter care hearing, there's kind of a window of time between the shelter care hearing and the next hearing, which is the fact-finding hearing. After the shelter care hearing, the social worker switches from a CPS social worker to a CFWS social worker. A CFWS social worker is a social worker who specializes in working with parents and children to work to reunify the kids. During that time, the social worker will be working with the birth family and their attorneys, working to reach an agreement. So this agreement could be that the parent voluntarily engages in a few services and quickly gets their kiddos back, or maybe the parent is resistant to engaging in any sort of services. During this time, if the issues are pretty major, the social worker will be working with the parent and their attorneys to agree to what's called dependency. What that means is the parent agrees to their child legally being placed in foster care, and their legal guardian then becomes the state of Washington, as well as the parent legally agrees to court-ordered services before their kiddos can return home. So if a parent agrees to dependency, this means their kiddo is officially in foster care, and this means the parent must engage in services adequately before their children may be returned home to them. Not all parents want to agree to dependency. It's a scary thing for the parent to know that their child is, a custodian of Washington State or dependent of Washington State. Parents might not want to agree to certain services. They might be nervous or not think that services are necessary. So if the parents are not comfortable agreeing to dependency, that means that the fact-finding hearing must occur. At the fact-finding hearing, it's a hearing where the social worker is going to spell out all of their concerns and why they believe dependency must be established as to the case. The parent and their attorneys will also speak to the court and argue as to why they believe that dependency is not necessary. In this middle time between the shelter care hearing and the fact-finding hearing, every 30 days there is what's called a continued shelter care hearing. Every 30 days post this initial shelter care hearing, the legal parties have to gather before the court and discuss the status of the case. Why are kiddos in care? What are the safety concerns, and why children cannot return home yet? So again, kind of in this waiting time, every 30 days, there is a reassessment of the case, what's going on, until dependency is established, either by an agreement and agreed orders between all of the parties, or going to trial and letting the judge decide. If and when the judge decides that dependency is necessary, a disposition hearing follows. A disposition hearing is the services part. So that is where all parties agree to what services are necessary to mitigate the safety concerns. These services could be substance abuse treatment, they could be related to housing, they could be related to mental health. A variety of things. It can be kind of cookie cutter services just based off of the concerns that led to the children being removed from the parents' care. Parenting services are also sometimes included in that. So at the disposition hearing, that's where everything gets formalized of what exactly the parents need to do to get their kiddos back, as well as it's stated in court and formalized the role of this social worker and what they are legally obligated to provide to the birth parents. From there, 6 months later is the first dependency review hearing. So again, all the parties gather before the court to discuss what's been going on, what services have the parents been engaging in, how are visits going between the kiddos and their parents. If there are any issues that need to be discussed, those might be heard at this dependency review. Up until this point, kind of in this first half of the case, kiddos could be returned home at any point in time if the judge decides and rules, or if all of the parties are in agreement. So the parties being the parents, the social worker, the guardian ad litem, who is also a legal party to the case. The guardian ad litem is looking out for the welfare of the child. So at any point in time, when all of the legal parties are in agreement or the court decides, kiddos might return home. As well as priority is always for kiddos to be placed with relatives. So if at any point along all of this time a relative is identified and willing to be placement for kiddos, that will take priority. So at the first dependency review hearing, the case was heard to discuss how parents are doing, if they're making progresses, and maybe if parent-child visitation should expand. In this 6 months between the first dependency review hearing and the permanency planning hearing, if the parents are not making progress with their services or level of engagement with the social worker and their kiddos, the social worker might need to start concurrent planning. What concurrent planning in foster care means is that social workers always have to be working on plan A, which is return home to the parent, and plan B, what happens if that's not possible. So usually plan B will mean either guardianship or adoption. During this time between the dependency review and the permanency planning hearing, the social worker might inquire with you and your family to ask if you are open to being a permanent home to the child. So either a guardian or an adoptive home. This is a good conversation to have, and it's important to think about, but you need to keep in mind that we never know what to expect. So at any point in time, the social worker might ask you if you're willing to adopt, and it might be moving on a trajectory towards adoption, but if the parent starts making progress and engaging in services, or if a relative steps forward and says, hey, I'm willing and available, the plan might change. So it's important to be thinking about permanency and thinking about your levels of commitment to kiddos, but keep in mind that it's still very much an open case that you never know how it's going to end. So the social worker will inquire about what the potential permanent options are, and then the permanency planning hearing happens. So that permanency planning hearing, that's about a year after dependency is established, is where, again, all of the legal parties are going to gather before the court and talk about the progress that the parents have made, their level of engagement. If the parents are not making progress, the social worker, along with the state of Washington, might make the recommendation that the primary plan change from reunification to adoption. Now, this is usually just a legal switch. The social worker is still very much so working on reunifying the child with their parents, but that switch might happen if the parents are not making sufficient progress at that point in time. So the social worker might make a recommendation to the court, which could involve a switch of the plans. The parents and their attorneys, again, will argue for what they think is in the best interest of the child, and the guardian ad litem will also make a recommendation as to what they believe is in the best interest of the child, and the judge will ultimately decide. So the judge could say, let's leave it as is, let's keep the primary plan of reunification, or they could agree to switching the order of the plan from reunification primary to a primary plan of adoption. During this time, this 6-month window, again, social worker is working with birth parents on service referrals, on helping them get what they need to successfully reunify with their kiddos. Visits will be happening between kiddos and their parents. All of that stuff stays the same. And then again, there's going to be a 6-month check-in after that to say, hey, what's the status of the case? And also, do we need to start talking about termination? So at a certain point in the case, if parents are not engaged and are not making progress, then the social worker might need to begin the proceedings to terminate parental rights. This is still at least a 6-month process after a referral is drafted, and so we'll get into that later, what all of those nitty-gritties look like. So then the dependency review happens. Again, social worker might start working more on termination if by this point in time the parents, it's not looking good for kiddos to reunify with their families. At any point in time during this legal journey, kiddos could return home to their parents if the court agrees or if all legal parties are in agreement, as well as kiddos can move to a relative at any point in time that a relative is available for them. So keep that in mind. It's very much so an unexpected journey, and you never really know with each case what is going to happen. And that's where Skookum is here to support you and walk alongside your journey, whatever that looks like.